A very good afternoon, Shobna ma'am. Am I audible to you? Good afternoon, Shobha ma'am. Am I audible to you?
Yes, you are audible.
Yes. A very good afternoon to all in one present here today on the 10th day of the 15 days online refresher course on teaching pedagogy in legal studies, commerce, and social sciences, organized by Department of Legal Studies and Research, Barkatullah University, Bhopal, Droid Penal Group, a unit of Arjun Das Gulati Memorial Society, Prayagraj, and Chitrakoot, in collaboration with Guru Angad Dev Teaching Learning Center, a prime center of Pandit Madan Mohan Malviya National Mission on Teachers and Teaching, Ministry of Education, Government of India. Today, for our 10th day and session 1, we have with us Professor Shobha Bharadwaj. Ma'am is the Dean of ITM University, Gwalior, and I, on behalf of the Head and Dean of Barkatullah University, Professor Mona Purohit, and our Managing Director, Ms. Gauri Gulati, I welcome you, ma'am, for the session. Ma'am will be speaking on the topic law and social transformation. Over to you, ma'am.
Thank you so much. First of all, good afternoon to all, and I'm a little nervous seeing so many doctors in the panel, and it's very fortunate, and my association with this university of Barkatullah University, it has been a long association, and a long association with Dr. Mona Purohit too. So I'm finding it a pleasure to be here on this platform that today I am associating with. The topic that I have taken today is, I think it's a very vast and very extensive topic that I have taken. And what I am going to do with the topic is that instead of taking it law and social transformation in all aspects, I'll take it specifically in relation to the women law. I hope I am going to do justice to the topic. So I'm just going to start with the topic. And in between, I would like to request you that there is a possibility, because there is electricity failure in some of the areas. So there is a probability that in between I may lose, but as soon as possible, I'll be joining again. So please forgive me for that. Now, starting with my presentation, the presentation which is specifically referred, I'll say specifically devoted to the women and law. So it's basically the impoverishment to empowerment that I'll say. As far as law is concerned, we can simply define it as a system of rules, which is used to regulate a society, or rather I'll say to control the society. So society is, we all know that it's a heterogeneous place where people of all class, caste, creed, color, gender, background, all of them decide in the same vicinity. So here it is very essential that no difference should be created amongst the people. irrespective of their identities. So here comes the role of the social change. Social change is something that I think every society is ready to welcome it. We look forward to welcome for the good changes that might take place in the society. And I think it's the only concept which is the permanent concept that we can see. Change is the basic rule of nature. And because of that change, we are seeing that the development that we have seen in the civilizations. So here comes that what is the role of in this regard, what is the role of law in that social change? So I believe that it's an instrument for creating a social change. Law is an instrument for creating social change, and it can be two ways. First is when the law brings change in the society, and another is when the society brings change in the law. So that shows that both are interdependent. Here, I would like to quote Justice Bhagwati, who has said about this when we talk about the law and social change. And he believed in this concept and he has said that if the law fails to respond to the needs of the changing society, then either it will stifle the growth of the society and choke its progress, or if the society is vigorous enough, it will cast away the law which stands in the way of its growth. So law must therefore constantly be on the move, adapting itself to the fast changing society and not lag behind. So when one says that laws are bringing in change in the society, he or she means that law is basically making the society follow it in order to bring a difference or a change in the atmosphere which is prevalent or which is in existence. So before we move on to I hope kindly mute yourself.
It is a humble request to the participants, kindly mute yourself until and unless it is not required to be unmuted. It is a request because basically leaves the resource person from one thought to another. So kindly mute yourselves, or I'll just mute it for everyone. Sorry.
Okay. I hope I'm audible.
Yes, ma'am, you are audible.
Okay. So because before moving on to exactly the topic, it is essential that we must discuss about the status of women that has been there in the society. So and how the law has been an instrument of social change for them. So as far as the status of women in India is concerned, I'm specifically discussing in reference to India. In this, we have seen that our old Indian tradition, if we see, it teaches us that Matri Deva Bhava, which means worship mother, thereby basically advocating that women should be honored with great reverence like goddesses. Women represents half of the population of society, but the harsh fact that we have, I think, experienced that females had been sick handled in each society. And it has been for a long time, and India has also not been the exception to it. We have seen it from this, we have seen from the tribal to agricultural societies and to industrial societies to the prepared states. So it's basically from the cradle to grave, we can see that women are below the clutches of numerous evils. They face discrimination, operations, violence inside the society, and ironically in the circle of relatives too. So it's though in India, women have always been glorified as goddesses to be adored. They have been respected for all the virtues they possess. But we have seen that there has been, in the past few millenniums, there have been great changes that have taken place. In early Vedic period, women enjoyed equal status with men. For that, we have examples from Rig Veda and Upanishads, which mention about the names of the women sagas like Maitri and Gargi. So, but afterwards, we have seen that there has been a gradual degradation of the status of women. And that has been because of these various socio-economic reasons which were there. And if I see it from the time frame, it's basically the deterioration approximately began from 500 BC. The situation worsened and when the invasions of Mughals were there, and later on by the European invaders. And this has not been only outside the household, but even in their homes, they have been facing these type of operations, these type of injustice to them. And unfortunately, that has happened is that the perpetrators of the wrongs, it has not only been the men, but also the women themselves. So it's an ironical situation. Here I would like to quote an American philosopher, Martha Nussbaum, who has signified in his book Women and Human Development some entitlements which are of universal validity. Martha says that as far as the life is concerned, it has to be a dignified life. She talks about bodily health, bodily integrity. She talks about the social basis of self-respect, non-humiliation, non-discrimination on the basis of gender, religion, ethnicity, race, etc. She even talks about the right to hold property. She talks about the employment which should be there on the equal basis to men and women. And if we consider all these points which Martha has referred in his book, we'll find that number of things which our constitution has taken care of. If we see our Constitution of India and women empowerment, we'll find that how the constitution has basically empowered women. So this principle of gender equality, will find that it has been enshrined very well in the Indian constitution. The constitution makers, or we can say our founding fathers, they were determined to provide the equal rights to both women and men. So the provisions which have been introduced in the constitution, they secure equality in general and gender equality in particular. So it not only guarantees equality to women, but also it provides the state with power to take measures of positive discrimination, which is I think a great favor to women, because it mitigates their the cumulative socio-economic and political disadvantages which they might be facing. Then we can see, if we see in the reference of the Constitution, the preamble, the fundamental rights, the TSP, and number of other constitutional provisions, so which are and the special safeguards also, which are there to secure women's human rights. As far as preamble is concerned, we know that it assures justice, whether it's social, economic, political, equality of status, opportunity, dignity to the individual. So it treats both men and women equally. It also imposes a fundamental duty on every citizen. So this is, I think, a very important element of our constitution, that it has been a fundamental duty is there on every citizen, that to renounce the practices which are derogatory to the dignity of women. So I consider it to be very important that as far as the grand norm is concerned, it has been very much alert about that in what way the country has to go on. In fundamental rights, we can see that Article 14 is there, which talks about the right to equality for women. Then Article 15(1) is there, prohibiting the discrimination on the basis of sex. So then 15(3), that talks about the basically empowering the state to take affirmative actions in favor of women. 16 is there, which talks about the equality of opportunity as far as the matters of employment is concerned. Then Article 39A is there, Article 39D is there, respectively talking about the right to an adequate means of livelihood and equal pay for equal work. Then Article 42 is there, which is talking about the just and human conditions of work and for maternity leave. Then Article 46 is there, so which is taking special care about the weaker sections of the people to protect them from social injustice and any form of exploitation they might be facing. Then we have in the panchayats, we have seen the reservations which have been given. So Article 243D we have to see. So number of the provisions are there which are ensuring that women are empowered by the constitutional framers, and they have been very much alert about it. And from the very starting, they were alert about this fact that women must be given the equal status in the as far as the constitution is concerned. Now, if we move on to, I'll just the emotions that I have towards the women. Being a woman, I think I may be more sensitive. So I'll be quoting some lines which says the willingness to listen, the patience to understand, the strength to support, the heart to care, and just to be there. That is the beauty of a lady. And I think these are the virtues which the females possess. But unfortunately, because I think these are the virtues which has at times become a disadvantaged position for women. Because if we understand on the understanding of the fact that the women are disadvantaged, so we can see that because they have a different set of emotional and physical traits. So it becomes more necessary that they are accorded special treatment. So there are several legislations which have been enacted for this purpose. So we'll discuss that. And as far as these legislations are concerned, they have a long history in India. Dharma Sutras and Dharma Shastras, we can see which were the earliest treaties having social legislation, and there were norms to deal with these civil and criminal cases. In medieval India, we have seen that Akbar has taken keen interest to prevent the social evils like sati, infanticides, child marriages, etc. Then we have seen Lord William Bentinck, who has passed about who was sensible and sensitive about this sati which was happening at that time, and he has taken a stand, and then sati regulation, which was banning sati, was passed. And we can refer to the efforts of different scholars or the reformers. We can say Raja Ram Mohan Roy and several other reformers were there whose contribution is equally memorable in this regard. So I hope the participants must keep themselves. I request the participants to please keep yourself mute. I think the organizers can mute them. So we can say here that this is the reason that several laws have been enacted to improve the condition of women. Several various mechanisms have been introduced so that the wrongs against women can be redressed. So massive volumes of enactments are there, and a lot of these laws, we can see that even in colonial period duration, these laws were made, like abolition of sati, then Widow Remarriage Act, Child Marriage Restraint Act, like the Payment of Wages Act. So these are some of that as far as the development of women or the empowerment of women was concerned, it started at the stage of when we were in the colonial rule. Then the specific laws which are related to women empowerment in India, I'll just put down some of the names of it, like the Equal Remuneration Act. Then we have Dowry Prohibition Act, Immoral Traffic Prevention Act, Maternity Benefit Act, Dowry Death, the Dowry Prohibition Act, Commission of Sati Prevention, Prohibition of Child Marriage. Then we have PCPNDT Act, Sexual Harassment of Women at Workplace, Prevention, Protection and Redressal Act 2013. So a number of acts have been there, which shows that the society has changed. At times, the society has changed because of the laws were there, and at times it has happened that because the society needed something, the requirement of the society was such, and that is why the laws have been introduced. Now, if we move on to that, how this formation, this process of formation of legislation happens, because ultimately it's not a process of one day. So for that, because as far as the empowerment of women is concerned, we know that there have been number of evils, number of operations, number of discriminations that she has faced in the society. So it's basically, as per my opinion, first of all, it's the awareness of the social evil in the society. And when that awareness is created, and which is normally, we know that it's through the reformers, through the people who are working for the cause of society. And after that awareness which has been created in the society, then it develops into the movement against that evil. And when that movement reaches to a stage, it has developed it to a stage that it can be formed as a legislation. Then proper requirement of the legislation is done. So it's a process that we can see. If we see that like any evil, because there have been number of evils, we were talking about sati abolition. Sati abolition was a practice in the ancient time, and we know that widows were burning on the funeral pyre of the deceased. So it was an age-old evil. And uh, first of all, it was prevalent amongst the ruling class, and then we have noticed that it became a general practice. So Raja Rammohn Roy's Brahmo Samaj, it was against the, they have headed the campaigns against sati. Raja Rammohn Roy, when he was against this, he has taken the Shastric prohibitions of sati from Parashar Samhita. So in that way, he has created the campaign for the abolition of sati. And then we have seen that, fortunately, Lord William Bentinck, he was also of a very a favorable, we can say, a person as far as the women laws was concerned. So he was also alarmed by the rise of the sati cases. So he passed the sati regulation of in 1829. But still, we have noticed that as far as cases are concerned, they were lessened because of this sati prohibition, which was working. But still, we have, I think all of us are aware of the case that happened in Sikar district, the Deorala village of Sikar district in Rajasthan in 1987, when Roop Kaur, she became sati. So still we had one or two cases which were reported, but it was a great effect of the law that has been brought in. So now we have Commission of Sati Prevention Act 87. So which has provided an effective prevention of this Commission of Sati and the glorification that was being done. Another evil that we have faced is of child marriage. I think as far as child marriage is concerned, it's not only about the girls. The effect of child marriage is on the boys too. Though the effect is more worse on the girls, but as far as effect is concerned, both boy and girl, both are being affected because of it. So it's another social stigma for the women that we can say. And it's a complex problem. And because of the, why it actually happened is because it was of the diverse concerns of the society. Because I think the girls are considered to be a liability. They are not seen as individuals who can contribute to the productively to the family or to the society. So it was felt that unless we have regulatory mechanisms to check it, these concerns, it would be very difficult to curb this menace. And why I consider this to be very important, because we know that child is the future of our country. So what have been the reasons which were responsible in the society? So for that, we can see that the religious or the cultural bases which were there, then the lower social status of the women in society, the problem of the dowry system was there, then poverty and economic status of the families, because we have seen that lower the economic status, lower the age of marriage. Then the illiteracy was there, inadequate educational opportunities was being given to the specifically to the girls. And another thing was the inefficient implementation of the legal regulation. So that has made the problem more complex. As when I'm talking about the child, and I consider it to be very important issue, because it's the human rights, the violation of human rights of children. When we talk about a child marriage, it's a violation of his right to participation. When he or she cannot say that they do not want to get married, it's a violation of the right of health, it's a violation of the right to employment, it's a violation of the right to dignified life, because uh, this empowerment which is leading to different type of operations, then free and joyful childhood is being ignored, it's being violated, because when they are being assigned with the additional responsibility, the premature pregnancies are there. This premature pregnancy and motherhood, when the child marriage is done, it's an inevitable consequence of the child marriage. So right to development is also violated, because the children is uh, expected to be in an adult role. So he does not get the conducive environment and the education. So all these are very difficult situation, and this needed a, an answer from the law, and that answer has been given. And now we know that because Ishwar Chand Vidyasagar and Keshav Chandra Sen, they were very vigorously, they have campaigned against this child marriage, and the legislations were introduced in 1860. And after that, with because the Child Marriage Restraint Act, when they were working, these social reformers were working for this, they got support from some of other social reformers, but unfortunately, still the bill was opposed by several people. But still, we have a law against it, and that's a welcome move. And yeah, because there are some of the parts of the country where we can see that on the occasion of Akshaya Tritiya, still the mass child marriages are taking place. But one thing is, I'll say that which is a welcome move, that the governments are alert about it now. And fortunately, we can see that Ministry of Women and Child Development, they have schemes like the Mission Poshan, Mission Vatsalya, Mission Shakti, which are where we can find the Anganwadis working, Poshan Abhiyans are being done. Then there are schemes for the adolescent girls, child protection schemes are there. So they are working or functioning effectively, and which is causing betterment of the girls. So this was one side of the when we talk about the law and social transformation in relation to women laws. Now moving into an area which is, I think, a lot talked about area, lot discussed about area, but still being felt that still the society has not moved, because there have been laws, but then the mentality of the society is also to be discussed. It is also to be given attention by the people. Although women, because we know that all the traditional crimes, women may be victim of any of the general crimes like murder, robbery, cheating, etc. But the crimes which are directed specifically against women, like the gender-specific crimes, so they are considered to be, they are characterized as crimes against women. Various new legislations have been introduced for that. Amendments have been made in existing laws with a view so that it can be handled effectively. But still, we know that as far as the violence against women is concerned, the occurrences of such violence are still rampant. As this crime against women is concerned, the violence which is there, so it is any act of gender-based violence that results in or is likely to result in physical, sexual, or psychological harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or private life. We can see the below listed crimes which are there. Like we have obscenity, number of sections are there. For your reference, I'll just refer the sections like section 292, 293, 294 of the IPC. Then we have another section which is very important, that is section 67 in the Information Technology Act, We have Indecent Representation of Women Prohibition Act in 1987. In case of the offense of dowry death, we have Section 304B, the Dowry Prohibition Act of that has Section 2 defining dowry when it is made punishable. Then Section 174 of the CRPC, Section 113A in the Evidence Act, Section 113B in the Evidence Act, so, which talks about the presumptions. So it's a very important, I'll say, the amendments which have been brought in. Acid attacks which were there in acid attack cases, which have been specifically in these areas, which has been very much prevalent. So for that, the sections which are there is 326A and B of IPC. Then we have 357 B and C of CRPC. Another very important aspect is outraging the modesty of a woman. We know that how in the case of Rupal Deol Bajaj, how she has fought for this all her life. So sections 354, 354A, 354B, C and D, IPC. Then another is 509 of IPC. In the case of rape and sexual assault, we have section 375, 376, 376A to D of IPC. So this has been a great journey, you can say. Number of legislations have been brought in, which shows that there has been a change in the society. The lookout of the society has changed, though it has not changed that much, but still it has changed. So, and it happened because at times the law has changed because of the society, and another time the society has required the law for which the law has been made. Now I'll give you an example where the women rights groups, they have been agitating for the legal reforms, so that the type of domestic violence is being faced, how that is to be tackled. So women groups have always been there. I'm not going to talk about the Domestic Violence Act, but one point I would like to refer here is that the Constitution of India has recognized, as we have seen, that women's equality. It has recognized that there has to be a right of right against non-discrimination. But the problem that we have faced is that these rights were not directly applicable within the private sphere of the crime, private sphere of the home. So it created a problem as far as the implementation of the law was concerned. In 1970s and early 1980s, we have seen that women, the two amendments have been brought in because of the women rights groups who have mobilized public and political opinion for addressing the violence against women as a criminal act. So in 1983, we have seen insertion of section 498A in IPC, cruelty. In 1986, we have seen 304B, which was added in IPC. Alongside these amendments, we have seen in the procedural law also there was some change, like insertion of 113A of the Indian Evidence Act, then 113B of the Indian Evidence Act, then 198A of the CRPC. So it shows that there has been alertness about making of the crimes and tackling with the situation which the women have been facing as far as the violence was concerned. Section 498A is related to cruelty, any type of cruelty which may be physical or mental cruelty. Section 304B enacted in 1986 and specifically it enacted because there was a need, there was rising number of cases of dowry deaths, and which were often they were passed off as the accidents or the suicidal cases. And because the death of the bride was usually happening within the four walls of the home, and due to the complexity of the marital family, little evidence was, it was very difficult to get any evidence. So address this concern, this section 304B was introduced, and we all know about that how effective this section has been there. Apart from there, we know that there have been some misuses of the sections. So I think it's two sides of a coin, because the thing which has been made for good of a person, there are always chances that it can be misused too. So there have been misuses of the sections too, as far as 498 is concerned or 304B is concerned. Now, presumption, as I told you, because presumption is something which has added value to the section 304B. Because 113B, the presumption as to dowry, that case, because when the question is whether a person has committed the dowry death of a woman, and then it is shown that soon before her death, she has been subjected by such person to cruelty or harassment, and it has been for or in connection with any demand for dowry, then the presumption of the court works here that person has caused the dowry death. So this has basically empowered the women who were facing such minas, that they could have they could have some relief from such provision. So together, if we take these sections 304B and section 113B, we'll find that it's a very effective section. Then we have 306A, where 113A of the Evidence Act works, which was also enacted in 83. Then the problem that I would like to, of the domestic violence that I have felt is, it's not, I'm talking about the Domestic Violence Act, but as far as the association of section 498A was concerned, why we have felt that the failure of section 498A has been felt. So if we see that while addressing the domestic violence, which has arisen from the inadequacies of the criminal law framework in dealing with an offense of this type, because the problem that we have faced is the criminalization of domestic violence is basically focusing on punishing the perpetrator. And another thing on which the possibly the framers have not paid any attention to it is that it has little or no space for addressing the needs of the survivor of the violence. So here comes a problem. In this specific context, if we talk, because we all know that the society we live in, because to understand, law cannot work in isolation. And when we talk about these type of provisions, women often they have limited access to the economic resources or any independent means of living, that they can be dependent on themselves, and they can feed their children as well. So due to this social conditioning and the structures, women's access to resources often, because it has been dependent upon the husband. And when he himself is the perpetrator of the offense, and in such instances, if she files a criminal case, which is going to cut off her access to such resource, so there is a possibility she may be thrown out of the matrimonial home as well. So she is going to be deprived of the monetary funds that she is going to get. So the problem here is that if she does not work in the paid economy, her husband is being arrested, which who is a sole source of economic this sustenance for her, then that is going to cease. Even if a court has directed the payment of maintenance, and because of the this case, if the man has lost his job, then because of the arrest, then also the women will lose access to economic resources. So here, what I feel is that without an adequate support, when you have made a provision, at the same time, it has to be seen from the other side as well, that without having an adequate support structure that is going to assure the women of shelter, of sustenance, then a women, if we expect a woman who is going to complain of the domestic violence, it is not going to happen. Because in such conditions, if the support structure is not there, she is going to face extreme barriers to legal remedies. So this is a very important thing which I have felt when I was going through this specific provision. Another provision I would like to talk about, and I think which has specifically taken interest by the social reformers in that regard, That was the custom of Devdasi, the system of Devdasi. It flourished in India since the ancient times, we all know. And however, in the British time, we have seen that several reformers, social reformers like Raja Ram Mohan Roy, Ishwar Chand Vidyasagar, Govind Ranade, a number of reformers, they have considered it as an evil because they considered it to be that it leads to possibly temple prostitution. So, but after 1880, we have seen that this was the by the reformers which was being done, but then we could see that there was a public opinion that has been built, and the educated middle class like doctors, journalists, administrators, social workers, they also advocated for the abolition of this Devdasi system and the dedication ceremony of the girls to the temple deity. So hence we have seen the emergence of like the Bombay Devdasi Protection Act. Subsequently, after independence, we have seen the Madras Devdasi Act, then Karnataka Devdasis Act, Andhra Pradesh Devdasis Act. So number of these legislations have basically eradicated, they have worked towards the eradication of the Devdasi system. Now, I'm moving to a very, very important aspect, and I consider that being a working woman and seeing our country in such a state that now I think it's a huge working force of women. So in that case, the notice that has been taken of the sexual harassment of working women by the Supreme Court, so that was I'll say it was a revolutionary move by the Supreme Court. The Act, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 was it was a much needed and long pending legislation because it provides an essential framework for remedies in wherever the cases of sexual harassment at the workplace takes place. So first of all, how it started. We all know that about the Vishakha judgment in 1997. Supreme Court, that was for the first time that the Apex Court has acknowledged sexual harassment at the workplace, and it was considered to be a human rights violation. And at the same time, it was noticed by the court that there is no law on the issue because the case highlighted the lack of civil remedies, both to prevent it or to punish the perpetrator in that regard. So it was considered to be that it's violative of the articles like 14, 15, 19, 21 of the Constitution. Taking this into consideration, Supreme Court issued guidelines to deal with sexual harassment at the workplace of working. The court has recognized that the right to life encompasses within it the right to live with dignity. I think that's the wonderful interpretations that we have seen, because when we talk about right to life, we have always been very clear about it, that it's not mere animal existence that we are talking about. We are talking about a right, which is when a person has a right to live with dignity for whole his life. So Supreme Court in this regard, when this case came, it relied on the Convention on the Elimination of all forms of discrimination against women, which was adopted by the General Assembly of the UN in 1979, and where India has both signed it and ratified. So in the judgment, Supreme Court has outlined some guidelines, and it has made it mandatory for the employers that they have to provide a sympathetic and non-retributive mechanism to enforce this right, so that gender equality of these working women can be ensured. So the guidelines which were laid down by the Supreme Court in 1997, they were to stay in force until the Parliament enacted the legislation in that regard. And we have seen that it was a long time. The legislation has, however, taken nearly, I think, 16 years to be enacted by the Parliament. So it was a long time taken. Then we can see, because this was a case of Vishakha, and NGO and a few social activists who have approached the Supreme Court, and they were highlighting the lack of laws in this regard. The immediate trigger that was there was the brutal gang rape of Ms. Bhauri Devi, who was a Sathin in Rajasthan and who worked to prevent child marriages. Due to the opposition that she faced from various sections of the society when she was working for this cause, she became target of the gang rape. And this was committed when she was undertaking her duties as a social worker. So this was very important, and very important issue has been touched by Supreme Court in 1997. Now, if we want to understand, because we all know about this, and still we know that as far as the implementation is concerned, still there are some lacunas that we can see in this, as far this Sexual Harassment Act. We would like to understand that what is exactly or what constitutes sexual harassment, what sort of behavior is punishable there, who is going to be held responsible, what is the who can complain, what is the grievance redressal procedure, what are the penalties in this, what type of procedure is adopted. So we can say that it's basically the unwelcome sexually determined conduct. It may be physical, it may be verbal, it may be non-verbal, it may include sexual advances, demands, requests for sexual favors, molestation, sexually nuanced gestures, comments, remarks, jokes. Jokes may be either verbal, textual, graphic, electronic, or by any other means or action. So it is basically a behavior which is unwelcome and sexual in nature at the workplace. But as far as, because there are chances, there are incidences where the consensual behavior may be there. So in that case, it is not going to be considered sexual harassment. But obviously, the facts are to be analyzed in each case. So physical contact and advances, demands or requests for sexual favors, passing sexually colored remarks, showing pornography or other offensive or derogatory pictures, cartoons, pamphlets, or saying jokes, causing or is likely to cause awkwardness or embarrassment for the female, unwelcome sexual overtones in any manner, like on the telephone, it may be an objectionable telephone. So telephone calls, SMS may be there, WhatsApp messages may be there, email forwarded may be there, which may be included in this. Then we come to that, what is workplace in that regard? So it has a very extensive definition in that regard. Sexual harassment has occurred during, obviously it is clear that it should have occurred during and in the course of the employment at the workplace. Now, what is to be considered as a workplace? So workplace may be because it may be a private sector, it may be a governmental, non-governmental, commercial, vocational, educational, professional, entertainment, industrial, health, finance. So in any type of organizations may be there. So as far as this workplace is concerned, it is not limited to the precincts or the premises of the organization. It includes any other workplace where the employee is located in connection with the work of organization. So it can be a field trip, business meetings, it can be any social event which is related to business. So in all these cases where the employer has been associated, so in that case it would be considered to be workplace. If we see Sexual Harassment of Women at Workplace Act, we'll find that there are a number of things which have been taken as the Act has defined, is exactly as Vishakha had done. But there are some additions which have been done, the additional circumstances which have been added in sexual harassment, which says that implied or explicit promise of preferential treatment in the employment. So that is also considered to be, in this case also, it may amount to sexual harassment. In the case of implied or explicit threat or detrimental treatment in the employment. Okay, so that is also considered to be hazardous for the women, and it would be taken as an act of sexual harassment. then implied or explicit threat about her present or future employment status, interference with her work, when creating an intimidating atmosphere in the society, in the office, or offensive or hostile work environment for her, humiliating treatment with her, which may affect her health, or it may be, when we talk about health, it may be physical as well as mental health or the safety. So in all these cases also, it will be considered, it will amount to sexual harassment. Now moving on to whom the complaint of sexual harassment may be filed. So that's also because as far as this act is concerned, in this we'll find that the complaint of sexual harassment, because this is for the organized as well as organized sector, because normally it comes to our mind that when it comes to the unorganized sector, who is going to take care of it? So unorganized sector is also being taken care of it by this act. The complaint is being in two ways it can be taken care. The complaint of sexual harassment, it can be filed before the internal complaints committee, which is to be duly constituted by the employer. Whatever the administrative units are there or offices are there which are having more than 10 workers, there the ICC is to be constituted. Where ICC has not been, internal complaints committee has not been constituted by the employer, then in that case where the complaint is going to be, so in that case the complaint may be filed before the local complaints committee, so which is constituted in the districts. So here the aggrieved person, in that case, he may reach to the local complaints committee if the complaint is against the employer. So that is also a very important provision, because there is the possibility that a person who is going to constitute a committee, and if the complaint is against himself, then how it is going to be, the whole process is going to be having objectivity. So in that case, the aggrieved person may reach to the local complaints committee if the complaint is against the employer. Another thing which has been added is a very good thing, that the complaint may be lodged on the SHE-Box, that is Sexual Harassment Electronic Box, which is an online complaint management system, and it is hosted on the website of the Women and Child Development Ministry. And this facility is available to women who are working in private and government enterprises. Once a complaint is submitted to the SHE-Box, it will be directly sent to the concerned authority. Whosoever is having jurisdiction to take action in the matter, it will be sent to him. So what we have seen is that earlier, in the case of if the organization has been unresponsive in that regard, the only option was to lodge a complaint with the police. With the complaints being monitored now in SHE-Box, organizations will set up their efforts to ensure that they provide a safe workplace to female employees, because now the greater strength has been given to women in that regard. As far as the constitution of committee is concerned, we know that the constitution of a committee is very important thing. So it has to be presided over by a senior level women employee, then two other employees who are committed to the cause of women, or who have experience in social work or have legal knowledge. So they are to be appointed. Then one member has to be drawn from NGOs or the associations which are working for the cause of women, or a person who is familiar with the issues which are relating to sexual harassment. And one thing which is mandatory is that at least half of the members need to be women. Then in the local complaints committee, we see that it is required to, the government is required to appoint a district magistrate or additional district magistrate as the district officer. And it is the responsibility of the district officer that he has to constitute this committee, local complaints committee. This committee is basically meant to receive complaints of what types of complaints are to be received by this committee. Wherever the internal complaints committee has not been established, in the case of such organization, if the establishment which is there, it has less than 10 employees. And another is when the complaint is against the employer himself. So in these cases, the local complaints committee will be taking care of. So it's chaired by a woman who is eminent in the field of social work and committed to the cause of women. Another female who is to be nominated from amongst women who are working in the block level, taluka, tehsil, ward or municipality in the district. Then two other members are there who are to be appointed from the NGOs or associations which are working for the cause of women. And one of them has to be essentially required to be a woman. Then Act also states that one of these two members should preferably someone who has legal knowledge or at least has a background in law. So this Act requires that one of the two members shall be a woman belonging to the SC or ST or a minority community. So the officer in the district who is dealing with the issues of social welfare, women and child development, he is an ex officio member of the local complaints committee. So this is very important, the legislation that I'm discussing. Then comes the time frame for the complaint, and which is, we all know that it's a 3 months period from the date of incident. And if it is if it is a series of incidents which has happened with someone, then 3 months from the last incident. So in such cases, if the time period is to be extended, so it's in the hands of the ICC or the LCC. If they find the existing such circumstances are existing, and for that they have to record the reasons that why the complaint is being because for condoning the delay, they have to record the reasons for filing of the complaint. If the woman who was sexually harassed, she is not in a position to file the complaint because she is physically or mentally she is incapable, or in the case of death or any other reason, then her legal heir or any other person may make the complaint in that regard. If the woman is not able to write it, then the officers have to, they are required to assist the women in making the complaint in writing. Conciliation process is also there, which can be initiated by the women herself and is carried out by either by the ICC or the LCC. And the aim of this conciliation is that they have to settle the matter between the complainant and the respondent. And the precaution that has been taken by the Act is that it prohibits any monetary exchange as a part of the settlement. So that's I think, a welcome step in this regard. And if the settlement has been arrived by both the parties, then at this stage the inquiry stops and the record of the settlement is sent to the employer for necessary action. The interim measures when the inquiry is going on. So during the inquiry going on, what are the interim measures that can be applied by the organization? So it can, if it is found appropriate, the transfer of the complainant or the respondent can be done to any other workplace. Respondent can be granted a leave for a period which should not exceed 3 months. She may be granted any other relief as per the rules in this Act. The leaves which is going to be granted to the women in relation to this, it is not to be counted. It is basically in addition to the leave for which she has already entitlement. So as per her terms of the employment. So this provision will find that specifically it becomes necessary in those cases where the respondents and the complainant, they are working, they are in the same physical spaces. So then it becomes at times essential because separating both of them ensures that further harassment and intimidation does not occur when the inquiry process is going on. At the same time, we'll find that because what I have noticed is that if the complainant or the respondent, any of them is being transferred, then it may be detrimental to them. So in situations where sexual harassment has occurred and the woman is transferred to another office, it may be on her own request as well. it may impact her career adversely. That is a possibility. Conversely, if we see if the respondent is ultimately, if he is cleared of his charges and the inquiry that he has faced, the 3 months for which he has been transferred or he has proceeded on leave, it may also be detrimental to him. So I think this does not appear to be a very ideal situation to handle the issue because there are other innovative ways are to be find out so that the free and fair inquiry can be ensured, that no intimidation takes place there and the inquiry is conducted freely and fairly. So this is very important. Now comes a very important aspect, that is about the false complaints, and which always has a possibility that the false complaints may be, because as I told you that every legislation, or I think everything in our life, it has two faces of a coin. So there are always chances that there may be the false complaints which are being lodged. So if the LCC or the ICC concludes that the allegations which were made, they were either malicious, or the complaint which has been made is false, or it's forged, or it's misleading, the documents are misleading, which have been produced as evidence. So in that case, the committee has all the power that it can recommend action against the original complaint. And then the inquiry will be conducted against the complainant, so that the matter can be adjudicated wherever the complaint is found to be malicious. So if it is proved, if all these elements are proved, then the action which has been prescribed in the service rule, it is going to be taken against the complaint. So I hope I am audible to everyone.
Yes, ma'am. Yes, it's audible.
So now we come to the appeal, and beautifully, after the recommendations which have been made by the inquiry committee, the appeal procedure is same as it has been prescribed by the service rules. And for that, the time which is there is that it has to be filed within 90 days. Duties of the employer, which has been decided in the case of the Shakha as well, and then the Act itself describes that it is the duty of the employer that they have to provide a safe working environment for all its employees. And as far as the constitution of IPC is concerned, the penal consequences of sexual harassment is concerned, it has to be it has to be displayed. It has to be displayed in a conspicuous place. Conspicuous, that is on a very clear place where everyone can see it. So just give me a minute. Then workshops are to be organized, awareness programs must be done so that the employees are sensitized, whether male employees are there or the female employees are there, they are sensitized for such issues. Organizing such programs even for the members of the ICC, because there is the possibility that they should also be equally aware of the provisions which are there, because whenever they are conducting any inquiry, so everything should be on their tips. Then providing necessary facilities to the ICC so that they can conduct the inquiry in a fair manner and without any obstruction. Another thing which is very important is that if a woman chooses to file a complaint, because it's not an easy, I think it's not a very easy way for a woman, even if she has been facing a case of sexual harassment, coming out with a complaint itself is a different move, and everyone does not dare to do it. So I think because it really needs courage, even because there may be cases, I think, where even if the women are facing, they are not coming forward with the complaints. So here it is the duty of the employer that they must provide assistance to such women if she has chosen to file a complaint under the IPC or any other law for the time being. It means that if she wants to go for the criminal proceedings, then also there the employer's duty is there that he should assist that women in that case. So now we understand that every organization is required to have an ICC. It becomes difficult to find, the problem is that ICC is being made, then LCC is being made. But what about when coming to the qualified person? Because it's really difficult to find appropriately qualified people who can serve on these committees. So another thing is that the getting of the external member, which is very important. Then at some places that act, that lacuna that I think I personally feel is that there may be a power differential between the respondent and the complainant. So in such cases, how the whole situation is going to be dealt objectively. Then in some of the cases, sexual harassment is like any other professional misconduct, it is being treated. And we know that it is not so. So, but still, I consider that act itself is an important beginning in relation to the women who are working, safeguarding the rights of women, which are guaranteed by our Article 14, 15, 19, and 21 of the Constitution of India. So I think that's a welcome move of the, and that has given all of women, and I'll say that has given the whole society, because now the parents are more, the education has made women strong, and at the same time, these legislations are making women strong. And whenever they are facing any such situations, they have the legislations that whenever they have that courage, they can come forward. So this is the case. Another concern that I have found, and I think the courts have also found, because we have now a legal framework for dealing with the cases of sexual harassment. But what about eve teasing cases? So a court has been concerned about it, and in the case of in 2013, as Somitharam's case was there, where the court has observed that every citizen in this country has a right to live with dignity and honor, and which is basically a fundamental right guaranteed under Article 21 of the Constitution. So sexual harassment like eve teasing of women also amounts to violation of rights guaranteed under Article 14 and 15. So it has become, this eve teasing has become a horrified and very disgusting practice. So consequences of curbing such a menace, at times it's very difficult. Women are being harassed. Sometimes it may lead to serious psychological problems. Even it may lead to the extent that the suicide may be committed. So because the young girls, young women who are approaching outside, if they are facing such consequences, if they are facing eve teasing, so it may create the health problems for them, which may be physical, which may be mental health affected. So it is to be dealt with. So we need a proper legislation in that regard also, which is of, I think, the extreme importance. Then, because the uniform directions are not there, certain directions which have been issued, we can say, so that this menace can be curtailed to an extent. That is of including to depute plain-clothed female police officers in the precincts of the bus stands, shops, stops, railway stations, metro stations, malls, cinema theaters, parks, beaches, public service vehicles, places of worship, etc. So as such situations can be monitored and supervised, the incidents of eve teasing can be supervised, they can be taken care of by these officers. Another duty which is cast upon is on the the heads of the education institutions who are having charge of it, the places of worship, cinema, theater, railway stations, bus stands, etc. So they have to take steps as they deem fit as per the situation, so that the eve teasing can be prevented. The helplines, women helplines, can be created in various cities and towns, So it can control e-teasing, even in public service vehicles, it can be done. And very important thing is that the passengers or the persons who are in charge of that vehicle, they should be, because I think this is the most crucial part where the passengers are there, wherever we are the co-passengers, we have noticed that we do not take care of it. Because if it is not happening with me, it's not my matter. So, but this is not a personal matter, it is a social matter which is to be taken care by each one of us. I hope I'm audible. If there is any problem, please let me know.
No, madam, it is audible and it is clear.
Now coming on to the future protection, because we have, we know that there has been cases of infanticide, but as far as future protection is concerned, we know that we need to be very careful about the female feticide. While dealing with the violation of preconception and prenatal diagnostic techniques, Prohibition on Sex Selection Act 1994, the emphasis was also made on the practice of female feticides in the case in Voluntary Health Association of Punjab in the year 2013. In this case, it was said that female feticide has its roots in the social thinking. It's basically the mentality, which is fundamentally, it is based on some erroneous notions that we have, the egocentric traditions which are there, the patriarchal setup which is there, the patriarchal perceptions of people. So all this is responsible for it. So all involved in this female feticide. So it because we are when deliberately it is being done, we forget to realize that when the fetus of a girl child is destroyed, it's a women of future which is being crucified. So this is a real issue of concern. And the repercussion of female feticide, it has been opened that every woman who mothers the child, they must remember that she is killing her own child despite being a mother. So that is to be taken care by the society apart from having the legislation. So what abortion means in social terms, it's basically abortion of abortion of a female child. It leads to killing of a woman. So law prohibits it, scriptures are forbidding it, philosophy condemns this act, ethics deprecate it, morality decries it, and social science abhors it. So it's basically, when we have the acts, it's basically the society which has to work upon those acts. So it's the mentality of the society which needs to be changed. We have to think in that regard. Now moving on to two, three judgments that I would like to quote before you, and which I consider to be transforming judgments. Every one of us knows about it. I'll just refer it here. The the judgment of Sabrimala. Here, a Hindu pilgrimage center in this Periyar Tiger Reserve in Kerala, the Ayyappan temple in Sabrimala. It clocks about, I think, 50 million devotees every year. So women who are between the ages of 10 and 50, they were kept out. So we have seen that a five bench judge comprising Justice Nariman Kanwalkar Saab, then we have Justice D.Y. Chandrachud sir and Indu Malhotra ji. So it was led by then Chief Justice, Honorable Justice Deepak Mishra. It overruled the Kerala High Court's 27-year-old decision, which restricted the entry of women in that temple. Okay, so this is, I think, a transforming judgment. There may be difference of opinions in this regard because it has a number of people might be having an opposition towards it, but this is for reference. I have told you. Then another very important judgment, and I think we may be on the uniform opinion we might be having about this judgment. That was when the adultery has been made to be no longer a crime. So Supreme Court has, in Joseph Shine versus Union of India, Supreme Court has struck down this 158-year-old section 497 of IPC, and it has said that this law is unconstitutional because it treats a husband as the master. So any provision of law which is affecting individual dignity and equality of women, it invites the anger of the Constitution. Constitution frowns in such situations. So it's a time to say that the husband is not the master of the wife. Legal sovereignty of one sex over other sex is wrong. Then very important case, I think we all agree on this point, that is the Nirbhaya case. And what we all have felt about this case, I think it's a terrific incident that has happened, and the feelings that have been there when the case happened and afterwards also. In 2012, when this case happened with a female physiotherapist intern student, she was beaten and gang raped in Delhi, and she died from her. She could only survive for 13 days, though she was given treatment in India and Singapore too. But still, she could not survive the injuries which have been caused to her. So the incident has generated, it was so brutal that it has generated international coverage. And there was condemnation from everywhere. There was condemnation from the United Nations entity for gender equality and the empowerment of women, who have called on the government of India, government of Delhi, that everything should be done in their power to take up radical reforms. And justice should be ensured. And they should reach out with robust public services to make women's lives more safe and secure. So public protests took place in Delhi. We all know about it. And it was not in Delhi, even in other parts of the country. People were furious about the situation. Thousands of protesters were there who even clashed with the security forces. And so this was a very alarming situation. And this case, because this case, when it was in progress, the sparking angry protests were there. It was putting focus on these sexual crimes against women, and the incident has shocked the whole country. So then it prompted the government to set up a judicial committee so that more stiff laws can be proposed to deal with such cases. And this spurred faster prosecution, harsher punishment for the perpetrators. And here also, Honorable Chief Justice Deepak Mishra, he has awarded the death sentence. And in his verdict, he says that the casual manner with which she was treated and the devilish manner in which they played with her identity and dignity is humanly inconceivable. It sounds like a story from a different world where humanity has been treated with irreverence. So I think it was a case which has just transformed the whole scenario in this regard. And now people, the psyche of the society or a mentality of the society has also changed in that regard. And even the lawmakers, the law framers have been very alert about it. And the governments have been alert about it, that women should be provided with the safety. I do not say that all women are safe at every place, but still I think the situations are improving, and we feel that we are proceeding towards a great future where all people are going to be safe. It's not only about women, it's every person in the society is going to be feeling safe. Another case was of Bodhisattva Gautam case, where the court has observed that women have the right to be respected and they are to be treated as equal citizens. So it says that their honor and dignity cannot be touched or violated. They also have the right to lead an honorable and peaceful life. So this is, I think, the case which was a very important case, though old case. Now moving on to one thing which I would like to say is that which I have not talked initially, and but I consider personally, I consider it to be very I consider it to be very important that the Parda Pratha, which is prevalent in, I won't say that it is prevalent in South, because South has been, I think, protected from this. But as far as North India is concerned, still the Parda Pratha is there in some of the areas. And I think this is the time that, because there have been times when it has been accepted, but now this is the time, because this creates a barrier. It creates a barrier in the progress of a women. So this, personally, I feel that it should be addressed. Another point that I would like to touch upon is I think, which is long debated and long discussed issue, and nowadays a burning issue. And still, because the Law Commission is working for it, taking opinions from people, that is the concept of Uniform Civil Code. So intense debates and discussions have been done about it for several decades. We have been feeling it, we have been seeing it, we have been hearing it. The idea behind UCC is that to have a common set of laws which governs our personal matters such as marriage, divorce, adoption for all citizens, inheritance, irrespective of their religious affiliation. So India being a diverse country, having multiple religions and religious laws, so currently we have different personal laws for different religious communities. As far as Constitution is concerned, under Article 44, which is one of the DPSPs, it states that state shall endeavor to secure a uniform civil code for its citizens. However, the framers of the Constitution left it to the discretion of the government to implement UCC, because I think they also recognize the sensitivity and complexity of the issue. So over the years, I think various governments have come and they have discussed and debated the implementation of it. And now also we are seeing that debate is ongoing, discussions are ongoing. UCC started with the framing of the Constitution. And I think this issue has been kept alive by the judiciary as well as the, the political class. Again, it's in use, opposed and supported for various reasons. Some are supporting it for political reasons and some are opposing it for that very reason. Some are supporting it for sound social reasons and some are opposing it for other social reasons. So perhaps which are equally sound. So I think because I'm not taking it into detailed discussion because still the issue is in debate. So it needs to have a very long discussion. So I hope some other time we can discuss it. As far as if we talk about about the law and social transformation and with respect to women, if we say, so I feel that putting just an end to my words, that despite the constitutional safeguards, statutory provisions and plethora of pronouncements have been there to support the cause of equality of women. Changing the social attitude and institutions have not significantly occurred. But there has to be total optimism which is to be adopted so that we can achieve the requisite goal. It is necessary that we accelerate the process of change by deliberate and planned efforts so that the harmful social evils which have been there about the gender equality, they are buried somewhere deep in its grave. Laws which are written in black and white, they are not enough to combat the evil. It's a socially sensitive judge is indeed a better statutory armor in case of crimes against women than any penal statutes. So it's awakening of the collective consciousness which is needed today. And I think the responsibility has to be shared by the state. It has to be shared by the community, the organizations, the legislature who frame the law, and the judiciary, which interprets the laws and the constitution. So, so that it can give a stimulus to the legal reform in the field of gender justice. And dignity and opportunity, freedom of both the sexes equally can be ensured. So here I come to end of my presentation. I'll put some lines before you, and I would say that it's basically the thinking of the society, thinking of each one of us is to be changed We teach girls that they can have ambition, but not too much. To be successful, but not too successful, or they will threaten men. So all of us have to be very careful about it. I think it's now in the hands of the men and women both, that as far as the girls are concerned, they are on the equal platforms. Lord Denning has observed in due process of law when he says a woman feels as keenly, thinks as clearly as a man. She in her sphere does work as useful as man does in his. She has as much right to her freedom, develop her personality to the full as a man. When she marries, she does not become the husband's servant, but his equal partner. If his work is more important in life of the community, hers is more important in the life of the family. Neither can do without the other, neither is above the other or under the other. They are equals. So with these lines, I end my presentation. Thank you so much.
So I guess there are no questions from the participants, as ma'am has discussed her topic so well that there is no questions in the chat box as well. So thank you so much, ma'am, on behalf of Barkatullah University and Droid Pino Group, with our collaborators, Guru Angad Dev Teaching Learning Center. Thank you for taking out time for us from your busy schedule. Thank you so much, ma'am, for giving us this session on this 10th day.
Thank you so much. Thank you to Mona ma'am, and thank you to the organizers, and thank you to all the colleagues who might be there because I'm not able to see everyone. Thank you, Mona ma'am. Thank you so much.
Ma'am.
Thank you to all the organizers, and thank you to my colleagues and friends and all academics. Thank you. Thank you so much.
Thank you, ma'am.
So moving towards the second session of the day of this 15 days online refresher course on teaching pedagogy in legal studies, commerce, and social sciences. On this 10th day and session 2, we have with us Professor Shweta Bajaj ma'am, who is right now a professor at Gurugram University, Gurugram. So a very warm welcome to you, ma'am, on behalf of the organizers, Barkatullah University, through its Department of Law, and Droid Penal Group, Prayagraj. And this program is in collaboration with Guru Angad Dev Teaching Learning Center, which is a prime center of Pandit Madan Mohan Malviya National Mission on Teachers and Teaching, Government of India. So today, ma'am will be taking up a topic which focuses on enriching the culture and efficiency in higher education in the light of NEP 2020, with special emphasis on legal studies. So a very warm welcome to you, ma'am, and over to you. Ma'am, you're not audible. Please unmute yourself.
Am I audible now?
Yes, ma'am, you're audible completely.
A very warm good evening to all of you. And at the outset, I would really like to thank Mr. Gaurav Gulati and the Droid Penal Group and the organizing universities for this platform and for organizing this refresher course for the faculty and giving me a platform to share my views on the topic which Mr. Gaurav has just told. I'll repeat it. This is enriching culture and efficiency in higher education in view of NEP 2020 with special emphasis on legal studies. So I'll begin with what do we understand by the term education. Education, it is the act or process of imparting or acquiring knowledge. This is A. Second, which is very crucial, is developing the powers of reasoning and judgment. This is extremely important and crucial in the present time, because in the previous education systems, we have somehow missed on this particular part, and generally of preparing oneself or others intellectually for mature life. This is what is meant by education. And NEP 2020 aims to provide a holistic and flexible learning experience to students by minimizing the school curriculum, which I will not be taking up here regarding the school curriculum, since it is particularly for the higher education, with regard to the higher education. And NEP 2020 focuses on 21st century skills such as analytical, critical thinking, cognitive skills, experimental learning, and creativity. So these are the basic things on which NEP looks forward to add to our education system. And this NEP 2020, it replaces the 34-year-old National Policy on Education, which was formulated in 1986. The pillars of NEP 2020 are access, equity, quality, affordability, and equality. I would like to emphasize upon equity and inclusion. It implies no child should be left behind in terms of educational opportunity because of the background and socio-cultural identities. So special provisions have been made with respect to scholarship and relaxation in fee, and to support the education to socially, economically deprived groups. The salient features of NEP 2020 are, first of all, the vision itself is to directly contribute to transform India with respect to education and make it a global knowledge superpower. We will see in further discussion as to how this is going to be implemented, how nation is going to become global knowledge superpower. Basic principle of the policy is harnessing the unique capability of each student, focus on holistic development by ensuring participation of every student in both academic and non-academic spheres. See, one of the unique features here in NEP 2020 is it has given equal importance to academics, to extracurricular activities, to vocational training also. The aim is not the rote learning of the classroom, but the aim is far more. That is holistic development, that is development not only of intellect, but social, economic, extracurricular, entire thing to make a better human being of a student. And non-academic sphere is also given equal importance. Then flexibility. Another key feature is flexibility. What is flexibility? In terms of learners' ability to choose their learning trajectories and programs. Now, it is no more mandatory. It will be implemented slowly, gradually, but the policy states that it will not be mandatory to choose either of the subject, either one particular stream, like medical, non-medical, and it requires combination of subjects. They have multidisciplinary choices to add in. Then no hard separation between arts and sciences, curricular and extracurricular activities, vocational and academic streams. So no hard and fast separation. It is that the students have great choice to take up the subjects as per their preferences. Now see, it has various, besides flexibility of and giving an option to student it has quite a lot of other, benefits. One is we are preparing students not only to have a particular skill, rather they will be prepared to be master of different skills. And tomorrow they can fetch employment in many spheres. Vocational training is given so much of importance that it is added in school curricula also, and given a great weightage in higher education also, so that the students are prepared not only theoretically, not only academically, but they also learn certain skills to have multiple options throughout their lives to earn their livelihood and to grow. Multidisciplinary and holistic education across sciences, arts, humanities, and sports for a multidisciplinary world in order to ensure unity and integrity of all knowledge. Emphasis on conceptual understanding rather than rote learning. What happened previously was students just used to cram up, or law mein to especially this happens. They just used to cram up before their examinations, chalo ye pad liya, and then you write up in their examination and then just dump the books. And many a times students are able to score good marks also. But are they able to retain that knowledge? Are they able to retrieve that knowledge? Are they able to apply that knowledge wherever it is required? This is a big question mark. And NEP 2020 has answered all these questions by giving less emphasis to rote learning. Rather, it is conceptual understanding. What are the learning objectives? What are the learning outcomes of a course? Creativity, critical thinking to encourage logical decision making and innovation. Then is to imbibe ethics and values like empathy, respect for others, cleanliness, etc. This is also imperative for the growth of a nation, especially when we are talking about law students. They ought to learn ethics. Any advocate, if we see the Advocates Act, any advocate is a man of high respect and esteem in society. Are they prepared to be like that? I don't know. At times, we may say yes. At times, many cases, unfortunately, it is not seen that happening. So, special emphasis needs to be given to groom the children, groom the students of higher education also to with regard to the value of ethics, courtesies, empathy, and respect for others. To imbibe democratic spirit and deep sense of respect for the constitutional values, fundamental duties, and rule of law by redesigning the curricula. Here, I would emphasize that these values, constitutional values, are these restricted only to law students? No, these are not restricted only to law students. Others too ought to learn it. So the Constitution is one subject which should be added in the curricula of each and every stream, and in many universities it is mandatorily added also. Few subjects, even BCI has recommended to add 2 subjects, 2 more subjects, which it thinks that it is mandatory. But besides that, even gender sensitization, environmental law, these are few subjects which need to be taught to every student, and every student should be encouraged to opt for learning these subjects when they are given a choice also. Because these subjects, the contents actually make them aware what the law of the land is. And we all know ignorance of law is not an excuse. We ought to learn the basic law of the land. Then promoting multilingualism and the power of language. The power of language, when we study any stream, unless and until we have a good hold on language, we cannot be successful. And here I will not say undermine the importance of English. Many of our books of higher education are actually written in English. Though the NEP, it promotes multilingualism, it doesn't undermine the importance of English. Language, the medium of instruction should be English as well as another regional language. So NEP gives equal importance to regional, national, and English language. It also gives, when we talk about language, it also emphasizes upon Sanskrit, to learn it and to give the importance it actually has. Then NEP, it promotes life skills such as communication, cooperation, teamwork, and resilience. That is adapting to difficult situations. And along with this, when I use the term resilience, I would say that in today's scenario, when there is a lot of stress in any profession, this particular characteristics, this particular trait of resilience, if you master this, you can accomplish many things in life. Even as a lawyer, I will talk about a lawyer. A lawyer, he should not get, totally occupied, totally stressed by listening to any criticism. Criticism, so it is the game of the court. Anybody would criticize you, the advocate or the judge or your, at times, your clients. You may have to encounter criticism. You may have to encounter certain moments when there is a lot of stress. How do you come out of it? Only if you have these characteristics. You are resilient and you can adapt well to any challenging situation by making a balance of full control of your mental and emotional status. So you ought to be flexible with regard to that. To shift to regular formative assessment for learning. And these particular skills, life skills need to be taught along with your subject. Here I would here I would really want to mention it, that when we are teaching a particular subject, along with teaching of the subject, we need to have the vision of NEP 2020 also. So consider it bilingual, multilingual languages. You can use 2 languages in the class, 3 languages in the class, so that the students are able to understand very properly. The content should be understood by the students. It should not be an overhead transmission, right? And along with that, you ought to learn the communication. You ought to inculcate in them, imbibe in them life skills such as communication, cooperation, teamwork, resilience. And then NEP 2020, it shifts from formative assessment, which is the assessment done at the later stage, at the end of examination. It shifts from formative assessment to summative assessment. Summative assessment to formative assessment. It shifts from summative assessment to formative assessment that encourages today's coaching culture. Like, it doesn't give emphasis only to what the student will not be evaluated only at the end of the course. No, the student ought to be evaluated to know how much is he learning throughout the course. That can be done by various modes. How? By declamations, by debates, by group discussions, by holding a seminar, by moot courts. We can do it through any modes. But yes, and by holding seminars, these things can be done. Formative assessment can be done. Extensive use of technology in teaching and learning. We all have gone through the pandemic phase. Had it not been the technology, we would not have been able to take the classes. the classes could not have been continued. So in all situations, the courts too are moving in hybrid modes, and usage of technology is being to the maximum. Respect for diversity and respect for the local context in curriculum, pedagogy, and policy. Teachers and faculty are the heart of the learning process. Yes, NEP 2022 also acknowledges it, and very good provisions regarding to very transparent recruitment of teachers have been given in NEP 2020. Then NEP 2020, when we talk about the provisions relating to teachers, NEP 2020 gives entire autonomy to teacher regarding the pedagogy of teaching adopted by the teacher. Teacher has full autonomy to adopt various modes of pedagogy to teach the subject. So, and this obviously good news, the salaries, it would definitely increase. NEP 2020 has the provision of transparent recruitment and good wages. Teachers and faculty encouraging innovation and out-of-the-box ideas. So teachers are also encouraged to think on out-of-the-box ideas, and that is why autonomy is given to them. Outstanding research. One thing where we are really lacking as compared to other countries is the research work. We ought to vigorously indulge in it and do very good research. And a very big reason why we are lacking on this particular aspect is lack of funds. And yes, for that also, there is a provision of, I will discuss about the authorities later. National Research Funding Authority has been established so that funds are given to for the research work. Grants are given for the proper research work. Then deep-rooted respect and pride in India. India has a very good cultural heritage, known for its cultural heritage, and NEP 2020 by its provision makes it mandatory to promote the cultural heritage by including arts, languages, and the dance, music, etc. into the curriculum as mandatory. And equal weightage is given to these subjects so that we are able to preserve our culture. Many of the languages, India is a place where there are many languages, but unfortunately, few languages are slowly dying. So in order to preserve all the languages, special provisions have been made in NEP 2020 so that the languages are able to sustain and grow. Substantial investment in a strong, vibrant public education system. Private and community participation. Yes, private higher educational institutes will also be given importance, and regulations will be set up to promote education by them, to generate funds by them. And then I would talk upon quality of higher education towards a more holistic and multidisciplinary education. This aims to develop good, thoughtful, well-rounded, creative individuals. The aim of this enhancing the quality of higher education is to develop good, thoughtful, well-rounded, creative individuals. It aims to develop all capacities of human beings: intellectual, aesthetic, social, physical, emotional, and moral in an integrated manner. No sphere is left behind. Only when all these capacities of a human being are developed, only then the human being will be able to deliver what he has learned. The application of knowledge depends upon holistic, is directly related to his holistic development of a person. So emphasis is given upon all these. Multidisciplinary studies. It must enable an individual to study across a range of disciplines and offer choices to make combinations: sciences, social sciences, arts, humanities, professional, technical, and vocational subjects. Even engineering institutions such as IITs will move towards more holistic and multidisciplinary education with more arts and humanities. This will also encourage the engineering students to know how to use the technology as per the requirement of the society. Students of arts and humanities will aim to learn more of science, and all will make an effort to incorporate more vocational subjects and soft skills. So the emphasis is upon multidisciplinary studies, upon vocational training, upon soft skills, upon holistic development, upon cognitive abilities. The stress is upon these things. Flexible curricular structure will enable creative combinations of disciplines for study and would offer multiple entry and exit points. This is also very interesting. The entry and exit points. A student, as the graduation will be for 4 years. After class 12, if a student wants to enroll for a graduation program, it will be not of 3 years as it is now. It will be plus 1 more year. And that plus 1 more year would be dedicated to in research of a particular specialization the person wants to, selects to. And in case the person wants to exit, student wants to exit after doing first year, the person has the option to do so. He will be given a certificate program. And it eliminates the previous picture, previous scenario. Pehle kya hota tha? Like एक साल किसी ने काम, एक साल की studies के बाद what used to happen because of any financial problem or any domestic problem, if a person is unable to continue with the studies, what used to happen? वो एक साल waste हो गया. Now this will not happen. The student will be issued after completion of 1 year of graduation course. The student would be offered a certificate while going, and the credits would be added. If tomorrow he wants to start again, those credits will also be noted down and counted upon, and it will be all maintained by a software. Constructive public, and after 2 years, if a student leaves, he'll be given a diploma, a certificate ke baad diploma, and then degree course. Constructive public engagement and productive contribution to the society. Now, how it is not only the emphasis upon, only gaining knowledge. It is also about the learning outcomes. What are the outcomes of the knowledge you have acquired? How much are you able to contribute to the society? Focus is on this, and all the curricula would be styled, would be framed in the manner that it is, it has good learning. It has good learning outcomes, and the students are prepared to contribute more to the society. So this way, when we are reading all this way, the students would be enabled to lead a more meaningful and satisfying life and work roles and enable economic independence. Now, departments in languages, literature, music, art, dance, theater, education, mathematics. These departments will be established and strengthened at all higher educational institutions. Standalone institutions, jaise pehle the, it will be phased out slowly. Instead of standalone institutions, what will come? Higher educational institutions. Higher education institutions will also not focus on any one particular stream. It will include various other disciplines along with it. Then curricula of all HEIs shall include credit-based courses, which I have discussed. Academic bank of credit shall be established which would digitally store the academic credits earned from various recognized higher education institutes. जैसे कि मैंने पहले बताया, that in case a student leaves a particular college after 1 year, university after 1 year, and after 2-3 years, the student wants to join, the credits would be stored, and that would be an academic bank of credit. MERUs would be established. Multidisciplinary education and research universities will be set up and will aim to attain the highest global standards in quality education. This is another another thing which is being established, that is MERUs, multidisciplinary education and research universities. This will be set up, and the aim will be to attain the highest global standards in quality educations. HEIs will focus on research and innovation by setting up incubation centers. Importance is given upon incubation centers. Now, what is the relevance of incubation centers? Incubation centers are basically established in universities to encourage the students, the alumni, to start up with small entrepreneurship. They would be given access to all the infrastructure of the university, and they can start their entrepreneurship with the help and support of the university in the incubation center. Okay. Then the key changes would be, by 2040, all HEIs shall aim to become multidisciplinary education institutions. This is not a small change. It will take a lot of time, and it would be done in phases. Multidisciplinary universities and colleges with more HEIs across India will be established. Medium of instruction will always be local as well as Indian language. Faculty and institutional autonomy would be established. Then establishment of a national research foundation, which I told you that the research foundation would be established to provide grants and aids for research work in the nation by different universities. Governance of HEIs by independent boards having academic and administrative autonomy will be done. Board of Governors will be established. By 2030, at least one large multidisciplinary HEI will be near every district. So, it is one of the aims of NEP 2020 is to increase the gross enrollment ratio to 50% in higher education, to 50% by 2035. And it is not easy to achieve, because presently it is 26.3% was in 2018. And when we are establishing higher educational institutions in every district, it becomes easier for all to have access to higher education, and this way gross enrollment ratio can be increased. A stage-wise mechanism for granting graded autonomy or colleges through a transparent system of graded accreditation. Graded accreditation की policy रहेगी. Open distance learning will be encouraged, so that again it will help in gross enrollment ratio. Open distance learning, online programs will be encouraged, and single stream HEIs will be phased out over time. Jitne bhi single stream HEIs हैं, slowly they will be phased out, because what we have and what NEP envisages is that every HEI need to be multidisciplinary. The system of affiliated colleges, presently kya hai ki affiliated colleges are affiliated to different universities, but slowly this affiliation program will also be phased out. The university structure deemed to be university, state university, all these things will be slowly phased out, and it would be HEIs only, higher education institutions. Optimal learning environment and support for students. Students will be given an optimal learning environment. Institutions and faculties will have the autonomy to innovate on matters of curriculum, pedagogy, and assessment within a broad framework of higher education qualifications. All assessment systems should also be decided by HEI, including those that lead to final certification. HEI should shall also move away from high-stake examination towards more continuous and comprehensive evaluation. You know, what happens is that throughout the year, we are not focusing as to how much a student is learning. Now, this will be made mandatory as to how much a student is learning during the course, and that gradation marks would be given according to that. Each institution will integrate its academic plans ranging from curricular improvement to quality of classroom transaction into its larger institutional development plan. The HEIs will form an IDP, institutional development plan, in which they will integrate its academic plan ranging from curricular improvement to quality of classroom transactions. Counseling centers will be established for students. Then the concept of internationalization. India will be promoted as a global study destination, providing premium education at affordable costs. And International Students Office will be HEIMA. We will be encouraged under the internationalization. Students across the globe will be encouraged to come to India, take admission in the higher education institutes. And similarly, there is also a provision of collaborations, teaching collaboration and faculty student exchange program with high quality foreign institutions will also be encouraged. Presently also it is happening, but it will also be encouraged. And high performing Indian universities will be encouraged to set up their campuses abroad. You know, that type of education we want, that even it can be spread across the globe and campuses can be set up across the globe. And foreign universities are also encouraged to open up their campuses in India. And financial, and this will also help in cultural diversity. You know, students would be encouraged to see the cultural, to have a look of cultural diversity. Financial support for students, SC, ST, OBC, and other socially economic disadvantageous groups would be given scholarships. Vocational, special emphasis is on vocational education. Vocational education previously also was encouraged, but now in NEP, it is made a mandatory part, that reimagining vocational education. It is added in the curricula itself. MHRD will constitute a national committee for the integration of national vocational education, consisting of experts in vocational education and representatives from across ministries in collaboration with industry. Establishment of new National Research Foundation, we have spoken upon it, transforming the regulatory system of higher education. This is quite complex also, but slowly it would be incorporated. One is Higher Education Commission of India. It will be set, the 4 structures will be set up as 4 independent verticals within one umbrella institution, that is Higher Education Commission of India. First vertical is National Higher Education Regulatory Council. It will function as the common single point regulator for higher education sector, including teacher education and excluding medical and legal education. This will not include medical and legal education, but except for medical and legal education, National Higher Education Regulatory Council would be the regulator. It will function as a regulator for entire higher education sector except medical and legal education. Second is Meta Accrediting Body Consyogi, National Accreditation Council, NAC. Vertical of HES, third vertical kaun sa hai? Higher Education Grants Council, which will take care of grants and funding, financing higher education. Fourth vertical is General Education Council, which will frame expected learning outcomes from higher education programs. Now, for effective governance and leadership higher education institutions, in higher education institutions, when it comes to implementation of everything, it depends upon how well it is the leadership in the higher education institutes that they can actually implement the policies. Through a suitable system of graded accreditation and graded autonomy, and in a phased manner of over a period of 15 years, all HEIs in India will aim to become independent, self-governing institutes pursuing innovation and excellence. Board of Governors of an institution will be empowered to govern the institution free of any external interference. And Board of Governors shall be responsible and accountable to the stakeholders through transparent self-disclosure of all relevant records. It will be responsible for meeting all regulatory guidelines mandated by HESL. Now, last, it is promotion. We have seen that an entire infrastructure, they have made it on the paper. There are bodies which will come into place slowly, and these verticals will independently do their work, and the entire system will come in place, but in a phased manner, slowly, and we expect it to be done by 2035. Promotion of Indian languages, arts, and culture. As I told earlier, NEP 2020 has given special emphasis on preserving the Indian culture, the national culture and heritage, and therefore it is including the Indian languages, arts, and culture into the curriculum. Teaching and learning of Indian languages need to be integrated with school and higher education at every level. For languages to remain relevant and vibrant, there must be a steady stream of high quality learning and print material in these languages. And slowly, we will be developing more print material with respect to different languages, more audio material, more material in every mode to enhance these languages and promote these languages. A number of initiatives to foster languages, art, and culture in school children will be taken care of. And Indian Institute of Translation and Interpretation will also be established. IITI, it shall make extensive use of technology to aid in its translation and interpretation efforts. Sanskrit will be mainstreamed with strong offering in school. Sanskrit is an Indian language, but it is also globally acknowledged. The beauty of the language and the importance of the language is globally acknowledged. India will further foster it. For each of languages mentioned in the 8th schedule of Constitution of India, academies will be established consisting of some of the greatest scholars and native speakers to save these languages. Efforts to preserve all Indian endangered languages will be specially taken care of. So this is the crux of NEP 2020, what it will be actually doing. At times it becomes a little boring, but yes, these are the policies which will take shape slowly and gradually. But we are proud that eventually something has come up after a long time. 1986 के बाद अब आया है 2020 में this policy, and this has a very good vision, and it is also giving time frame that within a considerable time the policy will be implemented in letter and spirit. Now, before discussing the other part, that is efficiency in higher education, which I have discussed in the paper also. Besides that, I would want to tell a few things regarding teaching to law students. While we are teaching law students, we should be very much aware that we are preparing them for a field which is not so easy, and certain traits are required by the profession. What are the traits? Law students should be, many of these are applicable to any of the students of any stream, but here I am putting special emphasis on law students. 1, there should be known art of grasping knowledge. How to grasp knowledge, because law doesn't have a small domain. It has wide horizons, many subjects, and law students need to learn various subjects. So art of grasping knowledge is imperative. Various modes, learning can be done by various modes: media, video, audio, books to hai hi. Second is research skills. They should be inculcated, the methodology for research, how research has to be done through books, through manuals, through e-methods, etc. Then once you have gained the knowledge, grasped the knowledge, then comes the factor of retention. Retention is also very important. How can you easily retain a knowledge? After grasping, for retention of knowledge, you need to organize the knowledge in your mind, then in such a manner that you can retrieve it easily by practice. Then application of knowledge. Once you have acquired knowledge, grasped knowledge, retained knowledge, retrieved knowledge, then comes the skill of applying knowledge in solving any problem. So problem solving methods should be given so that they can apply the knowledge to solve the problem. Then transmission of knowledge. That is also very mandatory for any law student. They ought to learn the method of transmission of knowledge. Any good lawyer ought to have these skills, and besides that, some very important factors are knowledge gain ho gayi, retain ho gayi, retrieve bhi kar li humne, apply bhi karni aa gayi. Lekin kai baar, because of lack of oratory skills, we are unable to explain ourselves. We are unable to express ourselves. So students emphasis should be given upon oratory skills. Now, how oratory skills can be developed? Moot courts, debates, declamations, group discussions, etc. Then drafting skills. Students should not lack, lawyers especially should not lack in drafting skills. Their draft should speak their mind clearly. Then court craft. Court craft is an art. जिसको आ गया वो बहुत बेहतरीन लॉयर बन सकता है. तो कोर्ट क्राफ्ट कैसे सीख पाएंगे? कोर्ट क्राफ्ट तो तभी सीख पाएंगे जब हम एक्चुअली कोर्ट्स में जाएंगे. सो मोर ऑफ इंटर्नशिप्स. I would really emphasize more of internships, more of moot courts, more of inviting advocates, practicing advocates to the classroom to encourage them so that the students can see them as their role model. Then is social skills. It is imperative to teach them social skills. Technologically savvy, make them technologically savvy so that they are able to do the research work properly, and use the latest technologies, AIs, artificial intelligence. They can use the apps properly. Networking is extremely important for every lawyer. Networking is extremely important. Unless and until you have a good networking circle, you at times feel helpless. You don't get proper cases. You are unable to fetch cases. You are unable to get to a place where you actually want to. Networking always helps. Teamwork. Any lawyer, while working in a law firm, any lawyer should have those skills of teamwork, to have patience, to be flexible enough, and to cooperate well in a team. Resilience, I have already spoken on it. Very, very important to be able to come out of a stressful situation. Adopt courtesies and ethics is extremely important for any lawyer. Many a times you can convince a judge by the manner, by your body language, by the ethics you adopt in a courtroom. Then is, so yes, these are certain very important features which we need to emphasize upon building up a law student to a good lawyer, to a good, wherever, in whichever field he goes. It will, these factors will always help him while pursuing his legal studies. Now, you know, one of the other things which I want to discuss here is the learning process. Learning process, you have to make it very, very effective. Many times in classrooms, I have seen that students are unable to catch what the teacher is teaching, what to do at that times. Number one, you have to be very precise. You have to, first of all, equip yourself with the, the level of the students you are addressing. This is actually very difficult when we are talking online because we hardly know what the level of the students or the faculty or anyone is across that side of the screen. But in classrooms, when we are sitting, when we are teaching in classrooms practically, you should gauge the level of the students whom you are teaching. Many times in my practical experience, I have seen that the students are not well equipped with English language, right? We can use bilingual, we can use Hindi while teaching, but after all, they will be reading English texts. In higher education, more texts are available in English language. So they'll be reading more of English texts. How can we take them to that level? That is very crucial. So be empathetic. And now, since the NEP 2020 is giving you autonomy in adopting teaching pedagogy, so you can very well, take up the modes, how you can equip them with the knowledge in various ways so that they are able to catch the language, English language. Then is repeated exposure. Sometimes people say that repeating for learning, repeated exposure to material, going over notes again and again, notes ko padh lo, learn ho jayega, notes ko padh lo, learn ho jayega. This is actually not the correct mode of learning. We can do it, but this is not the correct mode of learning. This will live only very short life. This type of learning will have a very short span of life. Instead of it, we can, instead of these simple rehearsals or just learning padhi jao, and then you grasp all the knowledge, you are equipped for the examination. Iski jagah, what we can do is, we have to, while learning, book se hi chahe padh rahe hain, book se hi padhte, we ought to encourage the students also that identify the gaps. Learning में आपने पिछली बार जो पढ़ा और अब जो पढ़ रहे हो, उसमें कहीं कोई gaps थे आपकी understanding में. In case there are gaps, try to fill up those gaps. Then practice applying the knowledge you have gained. When there is a practical application of knowledge, you will be able to retain that knowledge. Then synthesizing what we have learned is far more challenging. Then it is also a very, very important factor, how to synthesize the knowledge which you have gained. That is combination, combining the ideas, the beliefs, the style, everything, combining all that you have learned, synthesize your studies. It is also an imperative process of learning. Then is, when we teach, we also learn. We should always remember, when we teach, we also learn. And it is very effective in deepening our understanding and making our knowledge more retrievable in future. So teaching, I always say, teaching and learning teaching to the student, when we are teaching in a classroom, the teacher and the student both are actually learning. Teacher is not only adopting the role of, delivering the knowledge. No. When the students are putting up questions and the teacher is answering, it is also a mode of learning. The teacher is also learning. And we can refer Robert B. Jock's research lab में. There has been new informative ways, general learning principles. It says that focus on one task at a time, get to know the objective of the course and the learning outcome, organize information properly, connect to what you are learning and what you know. What you are learning and what you already know. You ought to make a connection between both the things. Then is draw and while learning what you have learned, how to organize it in brain and how to retain it, you can make flow charts. You can make, this is a very old method, but very unique, and it really helps to retain what we have learned in the classroom. Then for exam preparation, footnotes are small notes, flow charts. These play a very important role. And with this, and further, I would also like to speak upon some innovative methods, innovative teaching and learning methods in legal education. What are certain innovative methods? One is, previously it was teacher-centric learning mode, teacher-centric education. Teacher-centric education. Teacher-centric education discourages the questions to be put. And it is only the delivery mode of teacher. That the teacher is delivering the knowledge, passing on the knowledge which she or he has acquired to the students. Very important to make a balance between this. This was the traditional teaching. Now it is learner-centric teaching. In learner-centric teaching, it is open for the students to acquire knowledge through various means. And then put up questions, and the questions are solved, and here the teacher will play the role of a facilitator of knowledge, and not only delivering mode, not only passing on the knowledge to the student, rather the student is questioning, student has acquired knowledge, and student is questioning, the teacher is answering those questions and becoming a facilitator in the studies. So I would say that it is not only the student-centric education, which is a better mode of teaching. Rather, I would say that both things need to be balanced. The traditional teacher-centric, where the teacher is giving lectures, and that lectures can be made mini lectures, so that it is not boring. Those lectures can be made mini lectures, and after the mini lectures, the students can be engaged in discussions, and there can be seminars, there can be other group discussions. It can be like that. And innovative methods the emphasis is not upon grasping the knowledge, rather the emphasis is on problem-solving abilities. Whether we have been able to increase their problem-solving abilities. Step-by-step logical problem-solving through knowledge delivery by the teacher is more suitable in legal education. The aim of legal education should be that students should become real problem solver who masters legal knowledge through problem solving. In problem solving approach, teacher is always a guide and a facilitator, right? So crucial role of teacher and student. It can be the student is becoming a guide, a facilitator, and you can use the methods of simulations, role playing, moot courts, that is done by moot courts, and group discussion, negotiation, and how to you can imbibe the practical skills in it, because the thrust is upon making them ready, preparing them for a future professional life. So how to equip them with these additional knowledge? It is by equipping them with the knowledge, practical knowledge. Start more emphasis, give more emphasis upon moot courts. Give moot courts, maybe there are two parts. One is arguing, one is preparing the draft arguments, and the third is research work. Give equal emphasis to all these things. And then build up their negotiation strategy. Negotiating in contracts is very important. Many corporate lawyers, they do these things they have to do these things, negotiating in contracts. So build up those skills in the students to do, to develop a good negotiating skill. Then drafting and vetting of contracts is also something which we can include in our practical skill training to the legal students. Then alternate dispute resolution methods, these should be taught, and role playing by moot courts. Teachers should have clear goals regarding the learning outcome. While doing these exercises, teachers should have clear goal as to what will be the outcome of these of the strategy they are adopting, of the particular activity they are adopting. What will be the learning outcome of this? Then we have often seen that students, if they are finding it difficult to learn, we should encourage group discussions. Group discussions is a mode whereby the learning becomes easier, because when we ourselves also, we see that when we are teaching, we get to learn so many new things. So when the students are encouraged to participate in group discussion and express transmit their knowledge, they will be able to retain their knowledge in a better way. Fine. And cultural heritage, since I've spoken about the importance of enriching culture by mode of NEP, and we have discussed various factors, I would again stress upon that the tradition, qualities, and culture of our country are very rich and have existed for a long time, and it is known across the globe. The country, our nation, is known across the globe for its rich cultural heritage. Now, culture also keeps evolving with time, and especially with globalization, it also tends to evolve. Certain things are in certain ways, this cultural, we can see cultural change also. It begins, but what to include in the culture in practice, I would not use word culture here, but rather in practice, slowly, is that once you are educated, once you are able to discern between what is right and wrong, your ability, you are able to harness what is right and wrong for the society, then only you can adopt things from various diverse cultures and incorporate and try to incorporate those in your own society. So education is the key. And moreover, we can say that, yes, NEP has made special provisions for the preservation of cultural heritage, that is by including all these subjects, the arts, the art, languages, music, plays, everything has been given importance and duly incorporated in the curriculum. There can be practically a lot of difficulties in, engaging with students. But yes, when we are, especially in the time when when the students are also equipped with the bookish knowledge through Google and AIs and etc. But then the role of a teacher is to engage them in such a manner that they become that the things, the traits we have discussed in NEP 2020, as well as in my session pertaining to the traits, the mandatory traits of a good lawyer, a law student, we should keep those things in our mind while teaching them and equipping them. Not only with a particular subject, it should not be subject-oriented class, only subject-oriented class. Of course, there will be the subject objectives, the course objectives, and the learning outcomes. We ought to pay attention to it. But since NEP 2020 has given enough autonomy to the teachers to adopt their own teaching pedagogy, it is imperative for the teachers to instill these skills in the law students. Here I'm talking about the law students, so that they are well equipped. The gap between the bookish knowledge and the law in practice is filled. The gap is filled, and the student and the students, when going out of the law college, feel so confident that they are able to face the court in a very, very confident manner. This should be the ambition. This should be the basic aim of our teaching to law students. And thank you so much for giving me this opportunity.
If the participants have any questions, they can just unmute themselves and have the questions. Is it okay, ma'am?
Yeah.
So any of the participants?
I would like to just give one particular, I've already explained the message, I've given them the message, but yes, one thing more I want to, besides, in my concluding remark, I told you that it is imperative when we are teaching law students that they, throughout their 5 years curricula, they are well equipped with the practical knowledge of law, in addition to the bookish knowledge, so that we are able to make them very confident while entering the courts. And presently, whatever the structure is, I have seen how we are doing internships. It is only in a very, very, they don't actually go to the courtrooms. They don't actually, this is in practice, what they are doing. But how can we ensure that they are actually doing the internships properly? Because unless and until we explain them the importance of internships, they will always be reluctant. Holidays hai, enjoy karo. It is not for enjoyment. It is not just taking the diary of an advocate, noting down the case and noting down the proceedings and coming back to the teacher and handing it over to the teacher and scoring the marks. This way of education needs to be curbed. We practically want them that during the duration of these 5 years, slowly the LLB 3-year would be phased out as per BCI also. But this should be our endeavor that these 5 years, we have to imbibe in these students that this is practically what is going to happen when you are out of your law school. This is going to be the scenario. Are you prepared for it? Are you prepared for this scenario? In order to be prepared, please stick down to the curricula, learn the importance of moot courts, learn the importance of seminars where the students ought to participate mandatorily, learn the importance of simulations, role plays, etc., whatever you are adding in your curricula, and then only you will be able to go to the courts in a confident manner. Another point which I want to talk about is, I missed this point. Many a times we teach the students the law, especially I would say women's right. We teach them that yes, these are the laws, these are your rights. I'm taking example of these women rights. These are the laws. Domestic Protection of Women from Domestic Violence Act. These are the laws. You can sue them, you can take maintenance, and you can have this thing relief from a shared household, etc. You can seek protection orders, you can seek custody orders, you can seek maintenance orders. But we need to groom them the other way also. These are the clauses under which you can seek divorce. Your husband is being cruel, why not take divorce? Besides teaching them the rights, we ought to sensitize them about the aftermaths of these rights, of executing these rights also. Are they really prepared for it? These rights, when you go into a courtroom, these rights which you are seeking, how much are you going to pay for it? Pay for it not only in terms of money. How much are you actually going to give it to the courts? Engage in this litigation. If the things can be amicably solved, you ought to go in for the settlement. So the importance of settlement, the importance of knowledge of aftermath of things like divorce, these ought to be made known to the students right from the very beginning. Another important aspect. While we are teaching one particular subject, though we have learning objectives and the outcomes too. But besides that, we can establish linkages between two subjects. How one is related to another. Because courtroom में ऐसा तो होता नहीं है कि वकील जा रहा है वो सिर्फ एक ही एक्ट पढ़ के चला जाएगा. It doesn't happen that way, na? So we should try to engage with them with that respect also. Linkages of different subjects. Fourth, NEP has given due emphasis to professors in practice also. So whenever you are having and visiting professors also, whenever you are getting an opportunity to invite a practicing lawyer, be sure the students are enthusiastic about it and they ought to know the value of that particular lecture. Because in law, bookish knowledge is totally incomplete without having practical knowledge. And our endeavor is to make them understand both the things, practical knowledge as well as the bookish knowledge. We can't dispense with either of these. Yes.
So I guess ma'am has clarified a lot of things in her lecture, and now I, on behalf of all the organizers and the collaborators, would like to thank ma'am for her time which she gave for this session. Thank you so much, ma'am, for being a part of this 15 days online refresher course on teaching pedagogy in legal studies, commerce, and social sciences. It is a pleasure having you with us. Thank you so much.
Thank you so much. Thank you so much. It was indeed a pleasure for me too. Though I could not see the audience, that was a gap here. But next time, I'm sure we would manage that too.
Yes.
Thank